Well, thanks to all those who've joined us for attending this evening's webinar on the Planning and Infrastructure Bill. What's in, what's out, and will it work? All of us, I suspect, will be aware at least of what the government's aspirations are for this piece of legislation. It's, of course, an open question as to what extent, if any, we're going to witness a delta emerging between the lofty ambitions and what can be delivered in practice. It's a common experience to discover that it's harder to legislate one's way towards development and indeed other outcomes than to provide resources that might be needed to bring them about. But we're now at a stage, having seen the bill in its current form, to begin to understand what is the potential for this act to bring forward the government's agenda. We're going to be hearing from some very well-informed speakers this evening. They do not include me. I'm going to shut up after I've done the introductions. I'm Tim Morshead. I'm just here to chair things. We'll be hearing from Neil Cameron, King's Counsel, Jenny Wigley, King's Counsel, Reuben Taylor, King's Counsel, and Jacqueline Lean, who I'll introduce as we come to them in turn. First up this evening is Neil Cameron, King's Counsel, who will be talking about streamlining decision-making. Neil, actually, like a lot of the speakers on this call, probably most actually will be known to many of the people now listening. If one leaves aside Neil's experience in residential development, his major inquiries include things that most people will have heard about anyway: Custom House, the Tulip, the King's Lynn incinerator, the Leeds NGT. He's also appeared in Parliament on behalf of petitioners in relation to Crossrail and HS2. He appeared for Greater Manchester local authorities on the HS2 Phase 2B bill, and he promoted the Middle Level Act in the House of Commons and House of Lords opposed bill committees. He's also the chair of the Ebbsfleet Development Corporation Planning Committee. So Neil is someone who cannot say no to planning and infrastructure. Over to you, Neil.
Good afternoon, everybody. Sorry for the slightly slow start as somebody who can't say no. I'm speaking about streamlining decision-making. And one of the great frustrations with the planning system seems to me, and I think is a widely held view, is delay and how difficult it is to get applications dealt with in a timely way. And this is something that the government intend to address, and it's addressed in this bill. And there are three ways that it's addressed in Chapter 1 of Part 2 of the bill, and those are the ways that I'm going to talk about. And they are delegation of planning decisions to officers, training for local authority members, and changing the rules for fees for planning applications. So what I'm going to do is I'm going to say something about the current system, which we're all familiar with. And I'm then going to turn to what the government has done in identifying problems with the current system, what their objectives are, and what the solutions they put forward in this bill are. And then I'll have one or two observations about how it's going to work. So if we just turn to the current system, you'll all, as I've said before, be very familiar with this, but it's just worth remembering that when you have a local authority which has a separate executive, the planning application determination function can't be fulfilled by the executive, and generally it's fulfilled by a committee or by officers, and the power to delegate those decisions is in the Local Government Act. And local authorities are required to have a constitution, which includes their standing orders and their terms of reference, and I set out the statutory provision there. And most local authorities have a constitution which delegates decision-making to a planning committee or a planning application subcommittee and to officers. Councils also often operate a system which allows members to refer an application to committee. So it may be an application which is normally dealt with by officers, but a ward member notices a particular application and can get it referred to committee. But how does it work at the moment? A recent survey carried out by the Planning Advisory Service found that 3/4 of respondent councils have all of the following: a single planning committee made up of 9 to 12 members, a planning committee which is held regularly once a month and has a focused agenda of 4 or fewer items, and the meetings, one may think, quite long enough, but they don't last for more than 3 hours. And they also have a substantial delegation rate in that 90% of decisions are made by officers. So that is the current system. So what are the problems as seen by the government and others with the current system? And the government published a planning reform working paper, and they identified a number of problems, but these are the main ones. Lack of clarity on which applications will go to committee. Too much time is spent considering applications which are development plan compliant or dealing with post-permission matters, and that's too much time spent by committees. Insufficient understanding on the part of committee members. And it's also, this is another problem which the government identify. I think it's probably less of a problem, but lack of transparency. And the example given is when a committee refuses against officer recommendation. But when they do, in my experience, it's reasonably obvious why they're doing that. So what is the government trying to achieve? What are their objectives? Well, they want to achieve better quality development aligned with development plans. Good idea. Timely determinations. Good idea again. And they also want committees to focus on development which is not aligned with the development plan, where democratic oversight is required. And I think the idea behind that is that if it's in the development plan, there has been a degree of public participation, and therefore it's not so necessary for it to go before a committee of elected members. So what are the government solutions? Well, they are, in broad terms, to introduce a national scheme of delegation, to have mandatory training for committee members, and to enable local authorities to charge will inevitably, in most cases, be higher fees to reflect the cost of processing applications. So let's look at each of those in turn if we can. First of all, delegation. Well, a new section, snappily entitled Section 319ZZC, will be inserted into the 1990 Act. And I wish I could tell you exactly how this process is going to work and the ambit of the scheme of delegation, but I can't, because what the provision will do, if it is inserted into the 1990 Act, is will empower the Secretary of State to make regulations. And those regulations will require a planning authority to delegate functions to a committee, subcommittee, or officer, and they can do it either generally or in prescribed circumstances. So really, all I can say to you on that is watch this space for when the regulations come out. And then we got clause 46 in the bill, and that will insert section 319ZZD to the 1990 Act. And what that's going to do is enable regulations to be made about the size and composition of a committee discharging functions. And I think the The thinking behind that is that often you get very large planning committees, and that's not an efficient way of determining applications, because everybody wants to have their say. It all goes on for quite a long time and not always as efficiently as possible. Clause 45 will insert another provision in the 1990 Act, 319ZZA, and that's going to again enable regulations to make provision for training for planning committee members. And there will also be a provision inserted to make provision for training for mayoral functions, and that'll be when mayors, and I think we're going to see greater number of mayors, for when they're exercising planning powers. And how is this going to bite? It's going to bite because a member or mayor will be prohibited from exercising prescribed relevant planning functions, or a member from serving on a committee if they don't have a valid completion of training certificate. So will the objectives be achieved? Well, better quality development, yes, we all want that. It's difficult, I think, to see how the changes proposed will affect quality. But I suppose if you've got better trained members, they might be better able to ascertain what's good quality, but really that's down to officers, and it will work much as it is at the moment. Second, timely approval for development plan compliant development. That, in my view, is achievable. But of course, it depends on development plans being up to date. And if development plans aren't up to date and the cutoff or the criteria for it going to committee is it's not in accordance with an up-to-date development plan, well, it's not going to help much. But it may be that this will be an incentive for timely development plan preparation. Apart, of course, if members think that they still like to make lots of decisions, they won't be allowed to if there's an up-to-date development plan, so why get on with it? Thirdly, the idea is that committees should focus on schemes which do not comply with the development plan. That is entirely achievable and is a good idea. But of course, in very many cases, the applicant says it complies with the development plan and others say that it doesn't. So it's achievable, but it's not always easy to tell whether something is development plan compliant. So potential problems. There is an issue about whether the proposals will create a democratic deficit. And I think that's particularly the case where you have a controversial scheme, a big scheme, which may be development plan compliant, but local residents feel that they want to have a say and they want to see their councillors debate the issue. And that may cause resentment and concern amongst residents. Second point is, if decisions on major applications are to be made by officers, will members seek to, and I put this politely, lobby officers? One would hope not, but that is a danger. What difference will training make? Well, many committee members have training under the present system. But I think the new regime is likely to ensure that the quality and the range and ambit of training is consistent across the country. So that will be a good thing. But what happens if a member or members do not undertake training? Does that mean that the decision will have to be made by officers? It could do. We don't know the regime, how the regime will work. And that could cause another democratic deficit. So in all, I think the regime will speed up decision making, will improve the quality of decision making, but I do have a query about a potential democratic deficit. I'm now going to turn to fees. So clause 44 will amend an existing provision of the 1990 Act. And again, the Secretary of State will be empowered to make regulations. The fee or charge must be calculated or set with a view to ensuring that, so far as possible, it does not exceed the cost of carrying out the function in respect of which it is imposed. And the idea is that local authority can set a fee which allows them to recoup the cost of dealing with the application. Now, in order to stop local authorities just putting up the fees as much as they like, the Secretary of State has power to make a direction when she considers that the fee or charge is set at a level which is not appropriate. If a direction is made, the charging authority must review the fee, and the ultimate sanction is the Secretary of State can intervene and set the fee. So the new system will probably lead to a variation in fee levels across the country. I think this provision could be a good thing, because if higher fees are charged, and if the money is spent on employing more and more highly qualified planning officers, that is likely to lead to better outcomes. And the statute itself, if enacted, would require that the income from fees is applied to carry out planning functions. But I think it will be really important that the regulations make plain that the money must be devoted to dealing with the applications which are being considered, because otherwise applicants are going to end up paying more and they're going to get no better service. But if they do get a better service, it will be beneficial. The last thing, before I run out of time, is there has been quite a lot of publicity about statutory consultees. It's not in the bill, which we're meant to be discussing, but I thought it's worth a mention. The government are reviewing the number of statutory consultees, and they're also introducing a performance framework, or so that they will. And again, I think that is a good thing, because one of the major causes of delay in the planning system is waiting for statutory consultees to respond. So if it helps, that will be a good thing. So in conclusion, there will be streamlining. There is an opportunity for improvement, but as with everything, the devil will be in the detail of the regulations. But anything, as I say, which can be done to speed up the system must be good. Therefore, I certainly wish the government well in their endeavours. And I'm now going to hand over to Jenny.
I don't know. Can you hear me?
I can hear you now. Yeah.
Okay, right. Sorry. I was just thanking Neil for his remarks, especially on consultation, because there's one of the things that struck me is that there's been some work outside the field of the law. Some academics have been looking at this. It's a topic that's quite hot, including about the question of the extent to which extensive consultation is actually democratic at all. What we tend to find is that those who participate in consultation exercises are not necessarily improving the democratic process. They typically have their own agendas. And as Neil says, what ends up happening very often is a contribution that exceeds, in terms of delay, what is delivered in terms of improvement in the quality of decision making. So maybe there'll be some questions about that. But next up is Jenny. Jenny is a specialist in planning and the environment, as well as non-domestic rating. She represented the successful claimant in the statutory review challenge to all the Greenbelt allocations in the lead site allocations plan. She's recently promoted 2 large prisons for the Ministry of Justice and a sand and gravel quarry for a private developer. She's currently acting for claimants and defendants in a range of JRs, including a local plan challenge. And as all of that shows, Jenny has perspectives from the full range of parties involved in planning and infrastructure, developers, public interest groups, campaign groups, local authorities and central government agencies. So Jenny, over to you.
Thank you very much, Tim. I'm just checking I've got control of the screen. I think so. Yes, so I'm going to be speaking about chapter 3 of the bill, development and strategic scale nature recovery. And I'm going to start with looking at what is the problem that this is designed to address, so the current position, and that will particularly link in with Neil's comments about delay. And then I'll look at an overview of what the proposed reforms hope to achieve, a little bit of detail on what is in fact proposed, and then some reflections on whether it will work. So the current position, it's in 2 parts. There's everyone, I think, will be familiar or have at least have heard something about the issues thrown up about nutrient pollution and water abstraction. So nutrient neutrality requirements, water neutrality requirements. There's quite significant swathes of the country at the moment which are subject to these effective moratoriums on development due to protected sites, so protected ecological sites, being vulnerable to harm either from nutrients in wastewater or from water abstraction from local rivers and the like. And that means that large areas near those sites, include developments in those areas, are likely cumulatively to have significant effects on the integrity of the site, meaning that an appropriate assessment is required under the habitats regulations. And by that appropriate assessment, a developer is required to demonstrate the net impact of their development. So after recycling of water or other sources of water, how much take of water there will be needed, or how much wastewater will need to be absorbed by the environment. And then looking at that net impact, working out whether that can be mitigated to ensure that there is no adverse effect on the integrity of the protected site. And that very often includes the need to have offset sites. So in the case of water neutrality, to effectively pay other sites to use less water. And in the case of wastewater, to pay farmers or pay other developments to set aside effectively their fields so that they don't contribute to the nutrients in the wastewater. That can be quite a significant endeavour, involve agreements, involve finding willing participants, and quite often the lack of that available mitigation has led to the stalling of developments and, as I said, the effective moratorium on certain development in certain areas, thus thwarting delivery. And that issue is currently highlighted in the Fry case that you may have heard about, that's in the Supreme Court, that's been heard in the Supreme Court, and judgment's been is awaited on that. And in that particular case, the appropriate assessment was required right at the end of the process on the discharge of an unrelated condition, because that unrelated condition would have the effect of allowing development to proceed where there hadn't previously been an appropriate assessment. So it can kick in right at the end and can cause delays. So that's one of the issues that these proposals are designed to address. Another issue, perhaps less in the press and in the mind, is the issues of protected species. They're also covered under the habitat regulations, and quite often detailed surveys are required where the development is on a site where there's on-site habitat that would support those protected species. They have to be taken at certain times of the year. If there's a delay, they have to be updated, and it can result in the need for on-site mitigation measures and or a license from Natural England, and often further surveys. And again, another cause of additional cost and delay. So what do the reforms hope to achieve? At a very headline level, as an overview, we can see that from the planning reform working paper that was published in February. And as we all know, it's all towards this big main purpose of the new government, which is to assist in removing hurdles to the delivery of 1.5 million homes in this Parliament, and the determination of 150 significant infrastructure projects in the same period. And the idea is to deal with the environmental harms at source on a strategic scale, and by that achieve better environmental outcomes alongside increasing development growth. It's described as a win-win. Now, we'll just have a look at that and see whether that really is the case, or is it takist. So let's bear in mind which it is when we go through a little bit more of the detail. So just very brief overview of what's proposed, how it's all designed to work in principle. The idea is that Natural England will be required to prepare environmental delivery plans addressing potential harm to specific environmental features. Those will be prepared by Natural England, made and approved by the Secretary of State, and they will include a funding mechanism which will require contributions from developers, known as the Nature Conservation Levy. If the developer is prepared to pay that levy, then they will be able to bypass effectively the requirements of the Habitats regulations and the Wildlife and Countryside Act. So those provisions will be amended to enable impacts to be disregarded or licenses deemed granted where the developer is paying the relevant levy for the environmental delivery plan. That's the overview of how the structure works. So just looking at a little bit more detail, or before I do, just so you've got in mind the sorts of things that are currently going on, which are perhaps similar and which are mentioned by government in the way they've looked at this. One is district level licensing for great crested newts. So pooling that resource in terms of licensing rather than looking at very individual transmigrating a few individual newts, for example. A lot of you will be familiar with the SANGS mechanism, so suitable alternative natural green space to address recreational impacts on protected sites. That's been working for some time now, and that's perhaps the closest parallel to these environmental delivery plans, although those do work in a slightly different way and still engage the Habitats regulations. There's also the Marine Recovery Fund, and in terms of the levy, the indications are that it's likely to be based on the SIL framework, for better or worse. So those are a few ideas that the government's seeking to build on in these mechanisms. So a little bit more detail. What is proposed in relation to the environmental delivery plans? Well, first of all, each plan is set out in relation to a particular area, geographical area, and type or types of development. So that's what it's focused on, each one. It then has to identify the environmental features likely to be negatively affected by the identified development. And by environmental features, it means either a protected feature of a protected site or a protected species. So that's the type of environmental feature that it's focused on. Then it has to identify conservation measures that Natural England are going to take to protect those environmental features. And those conservation measures have to address the environmental impact of the development on the particular environmental feature and have to contribute to an overall improvement in the conservation status of that identified feature. Then it has to also identify a charging structure, so an amount of nature restoration levy payable by developers to Natural England to cover the cost of those identified measures. And then it also needs to identify the particular environmental obligations in relation to that development that would be discharged, disapplied, or modified if the levy is paid by the developer. So, i.e., identify the particular bit of the protected site or the feature which can be ignored when applying the Habitats regulations, so which can be bypassed in relation to the Habitats assessment or the appropriate assessment procedure. Okay, so that's an outline. Then what can it include in a bit more detail? It can include a combination of mitigation and compensation, as well as on-site measures. And it's specifically the case that environmental delivery plans will have the flexibility to diverge from the application of the mitigation hierarchy. Now, that mitigation hierarchy has been quite a bedrock of environmental law over decades, and particularly from the European derived legislation. And that hierarchy is avoid, minimize, restore and mitigate, and then only in the last resort, offset. The regulations specifically allow that to be bypassed. So, for example, there is specific provision allowing EDPs to set conservation measures that do not directly address the environmental impact of development on a particular environmental feature of a protected site, but instead seek to improve the conservation status of that feature elsewhere. So there is a weakening, as some may say, of what is required. You don't necessarily have to address it directly. You can offset it or improve it elsewhere. The EDPs will also have to include requirements as to Natural England's reasoning for the measures, and also a set of monitoring measures, review measures, along with the charging schedules. And the Act also sets out duties of Natural England, who they must consult, and specific matters and statutory provisions that they need to take into account when setting the EDPs. So, as I said before, it's a drafting exercise by Natural England, prepared by them, but will only come into force if it is made, so if it is approved and made by the Secretary of State. And it can only be made by the Secretary of State if the Secretary of State considers it passes the overall improvement test. And that is that the conservation measures are likely to be sufficient to outweigh the negative effect caused by the environmental impact of the development on the conservation status of each identified environmental feature. So note there, it's a different test from avoiding adverse effects entirely on the integrity of protected sites, which is, of course, the test under the habitats regulations. There's also a requirement on the Secretary of State to revoke any EDP if she subsequently considers that it's not meeting that test. And there are requirements for monitoring reports by Natural England to be produced during the duration, halfway through the duration of the EDP, which of course the Secretary of State would need to consider and test whether it meets that improvement requirement, and then consider whether to revoke or not. The Act also provides some compulsory purchase powers for Natural England if they need land required in connection with taking a conservation measure, so presumably things for offsetting or set aside, as I mentioned before. There's also a duty on other public authorities to cooperate with Natural England in the provision of information and assistance in the preparation and implementation of the development, the EDPs. And Natural England can require the imposition of conditions on planning permissions. And of course, the local planning authority under that duty to cooperate would be required to impose such conditions. There is a scope, an explicitly acknowledged scope for judicial review of each stage of the preparation of the EDP. So there's a 6-week time limit for a judicial review of the making of an EDP from the date of its publication. Similarly, someone can judicially review the Secretary of State's decision not to make a draft EDP, or decisions of the Secretary of State on amending or revoking EDPs. And in each case, it's a 6-week time limit, as with all planning decisions. At the moment, there's no proposed application of this to biodiversity net gain. I understand there are some rumblings in the background to bring this within the scope of biodiversity net gain, but at the moment, those requirements will run in parallel, and the bill does not propose amending any of the provisions on BNG. It is the intention from the working paper that these EDPs will be developed and brought forward in parallel with the passage of the bill, so that some are ready to go at royal assent. But we'll have to watch whether that in fact does occur. So then a little bit more detail on the levy. As I said, it has to be in a charging schedule as part of each EDP. The EDP can also provide, as long as they give reasons, that payment of the levy is mandatory. Now, this is quite a controversial issue, because that would remove the right of the developer to simply address the impacts under the habitat regulations and do their own mitigation. Instead, they'd have to effectively pay a tax to allow the development to go forward. But there is certainly provision for Natural England to provide that. And you can see how there would be reasons to require it to be mandatory, because otherwise it's very difficult to assess how the EDP can properly be funded if you don't know how many developers are going to opt into the levy. So we'll have to see how that comes forward. There's no detail at the moment. That's all to be set out in the Nature Restoration Levy regulations. In setting those regulations, the Secretary of State will be required to ensure the overall purpose being that the costs can be funded wholly or partly by a developer in a way, or by developers in combination, obviously, in a way that does not make the development economically unviable. So that's a tricky issue to be addressed, trying to balance exactly how much funding there'll be, taking that into account, and what the cost of the EDP will be, particularly if you're not sure how many developers are going to opt into the levy. The regulations also have to include a right of appeal on a question of fact as to the calculation of the amount of levy payable. They'll also have to include collection and enforcement provisions, and there will be a requirement, as with what Neil mentioned in terms of planning fees, there will be a requirement to ring-fence this money by Natural England and ensure that Natural England actually spend the levy on the specified conservation measures in the EDP. So will it work? Now, I'm just looking at this in two sides. Of course, there's two dual objectives of all this, which are potentially in stark conflict. One is, will it work by removing barriers to development delivery? And of course, will it work by continuing to protect the environment to the same extent currently? Looking at the first, will it work in terms of the objective of growth and allowing development to come forward quickly, and removing barriers and removing delays? It's difficult to say. I mean, in my view, it's quite a laudable effort to get this in place, but it all depends, of course, on those practical, difficult details of getting the EDPs in place, getting them funded, and resolving all the complex issues around what exactly are the features, what needs resolving, how many developments do you want to bring in within the scope of the EDP, how many will opt in, what time period are you looking at, how quickly can you see whether it's working. All of those complex issues are obviously dependent on the resources of Natural England, and potentially Natural England are going to have a huge raft of these EDPs to put in place. It's unclear whether and how they're going to be sufficiently resourced to do that. There's also uncertainty relating to viability issues. How closely will the viability of development be looked at to understand whether this will have a choking effect on the viability of developments coming forward? And how will the funding gap be met in terms of bringing forward those EDPs if you can only have limited funding from developers and the rest has to come from the public purse? There's also the potential for unfairness at an individual site level, because there'll be a lack of individual site assessment, almost by definition, because you're trying to remove that. That means there's likely to be a lack of proportionality of the levy amount to the harm caused by the individual development site. So there's quite a few issues that will need to be looked at in detail and may cause further delays or unfairness. Again, as I said before, if the levy is mandatory, that potentially removes flexibility to deal with issues at a site level and could stifle innovation in imaginative ways to neutralise any site-specific effects, and also would neutralise any site-specific advantage, both in terms of practical issues that a site may be particularly well suited to deal with mitigation, both in terms of where it's located or in terms of its ecological makeup. And if the levy is mandatory, all those advantages would be lost. But as I said before, it's quite difficult to see how an EDP and charging schedule could be properly planned and developed without a levy being mandatory, because there's so much uncertainty as to how many developers are likely to opt into it. Unless, of course, it's in an area where you've already got a blanket real problem with, for example, nutrient neutrality, and where there can be significant certainty that most or all developers are likely to opt in. There's also, of course, complexity in collection and enforcement, who's liable, how does that all work? And we've already seen, as a sort of prelude to this, how CIL can throw up quite a few issues, and we can see how those similar issues could be brought forward in the levy regulations. So will it work? I think it's got potential. It's got potential to solve some of the wide, the real complex systemic issues relating to things like nutrient neutrality and water neutrality. But it all depends on, the resources of Natural England to be able to develop these EDPs and make them work and make them free from challenge is the other issue. There's quite a lot of scope for legal challenge at each stage. On the other side, will it work by achieving better environmental protections? Well, it's intended to. We have the statement of Angela Rayner under Section 20 of the Environment Act, which is required, which states at the front of the bill will not have the effect of reducing the level of environmental protection provided for by any existing environmental law. And you can see how that's sort of aimed to be achieved, that, for example, these EDPs can only be made if there's going to be an environmental improvement, for example, the improvement test. We'll look at that in a bit more detail again in a moment. There's also, we can see that there, so I've just set it out on the slide, that there's a duty on the Secretary of State not to make it unless it's that improvement test, which is that conservation measures outweigh the harm. That's a balance, that's a judgment, and it's perhaps not quite such a tight judgment as under the habitats regulations. Also, if the EDP is seen not to be working, it's only really addressed, and the Secretary of State only really needs to address it when there's a reporting requirement by Natural England, which is at the midpoint. There's a requirement for a midpoint, a halfway point on the duration of the EDP. Natural England has to report as to how it's working, whether it is achieving the outcomes intended. And at that point, the Secretary of State will be required to revoke if it's satisfied it's not meeting those requirements. But there's plenty of potential for it not to be working before then, and for no one to be taking any action, and for development to be allowed to proceed whilst bypassing the requirements of the habitat regulations. So you can see how there can be quite a lot of concerns from an environmental perspective in relation to that. Also, it's worth noting that perhaps in order, obviously, to make it work in terms to enable this kind of deadlock on development, there is some loosening explicitly of the requirements of the habitats regulations. So, for example, the duties in Regulation 9 to secure compliance with the European directives and to have regard to those directives explicitly do not require to functions exercisable in relation to this part of the Act, so or the bill as now. So in terms of making EDPs, Natural England will not have to secure compliance with the habitats directives. And on the other way around, the requirement that there will be no requirement under the habitats regulations to have an appropriate assessment of those EDPs to check that they are ensuring no adverse effect on the integrity of the European sites. So there's a very clear carve out from the habitats regulations and effectively a loosening of those protections. And as I said before, there's express provision to depart from the mitigation hierarchy and to allow for harm to occur expressly to some protected sites, so long as it's compensated in relation to the particular feature elsewhere. And some people are very uneasy about explicitly allowing that to happen. So what's the verdicts? Overall, in my view, it's a good effort at seeking to cut through this very knotty problem that has particularly arisen in relation to nutrient neutrality and water neutrality, and that has a real thwarting effect on a lot of development, particularly in circumstances where development like housing is not necessarily the root of those problems, and where agriculture, for example, has caused quite a lot of the issues, particularly in relation to nutrient neutrality. So it's a good effort at trying to get around it, and I think there are clearly some wins that are possible. But on the other hand, I do think it is a little bit cakeist. I don't think you can entirely have your cake and eat it in relation to this. There will inevitably be some difficulties in terms of getting the wins in terms of economic growth, but also there will inevitably be some weakening in the environmental protection, albeit that that's not intended, and there may be efforts to not let that happen. There's going to be some leakage, in my view. So that's a very quick run through on the strategic planning for strategic nature recovery. I'll hand back to Tim. Thank you.
Thank you, Jenny. Can you hear me?
Yes.
Yes.
Yes. I can hear you, but not see you now, Tim. But
well, that's an improvement. By any count. Thank you very much for that, Jenny. You'll need to look at the Q&As because a lot of questions have come in, and I'm afraid most of them are directed at the topic you've addressed.
right.
Next up is Reuben Taylor, who specialises in all aspects of planning, environmental, compulsory purchase and compensation law, and acts for many of the leading developers, as well as central government and local authorities and private individuals, with expertise in the High Court, Court of Appeal, as well as advisory work and planning appeals, and with a particularly strong reputation for dealing with noise, road traffic, air quality, and other technical environmental impact issues. And lest we forget, he deployed those early in his career when he handled the Terminal 5 inquiry at Heathrow. So what would have been the highlight in our careers for many of us, for Reuben was just the beginning. So over to you, Reuben.
Yeah, sadly for many, they would say that was the highlight, but anyway, it's been downhill ever since. I'm tasked with looking at the measures in the bill relating to streamlining national infrastructure planning, and indeed the proposals for community benefits in relation to electricity transmission. I'm hoping I've got control of the screen. I'm not sure that I do, but oh yes, there we go. Right. First up, clauses 1 and 2 of part 1. These introduce matters relating to updating the NPSs in the DCO context. Of course, the primary policy context against which DCOs are assessed. The changes that are introduced firstly require each NPS to be updated at least every 5 years, with the intention that they're up to date and reflect wider government strategies. The 5-year period can be extended where there are exceptional circumstances that make delay unavoidable, and those have to be explained to Parliament. Secondly, there's an amendment to the parliamentary procedure for making material policy changes in respect of changes to reflect legislation, court decisions, government policy, or other documents. And that changes to remove the requirement for the Secretary of State to respond to any resolutions made by either House of Parliament or any recommendations made by committee. That, in a nutshell, is what those clauses achieve. In terms of where they take us in respect of streamlining infrastructure planning, the government's already announced that it's committed to updating all relevant NPSs by July 2025 in any event. So these reforms won't have any immediate effect on the NPSs because that process is already undertaken. In essence, it represents this government effectively imposing a duty on the next in 5 years' time. And so I suppose it's useful, but only if future governments stick to the 5-year programme. There are some downsides to regular updating of NPSs, because once an NPS has been in place for a while, all the case law develops on its interpretation and meaning, and things can settle down. If you shake the policy cast, as it were, that can attract challenges. So new NPSs do tend to get challenged. The airport's NPS, the TAN challenge to the National Networks NPS are good examples of that. So one might take the view, if one were entirely cynical, that more regular NPS updates mean more regular court challenges. In respect of the second element I spoke to, the amendments of the parliamentary procedure, it's difficult to see how removing the requirement for the Secretary of State to respond to resolutions made by either House or a committee speeds up infrastructure planning, although I can see why that might be convenient for the Secretary of State. So that's clauses 1 and 2. Clause 3 brings in some changes in relation to disapplying the need to actually follow the DCO procedure. It allows the Secretary of State to make a direction on a case-by-case basis that an alternative consenting route could be used. It requires application by the person who proposes to carry out the relevant development, or a person who has a power to make a local or mayoral development order. They have to explain why it's appropriate for the alternative consenting regime to apply, so it has to be justified. And you can't use the process if you already made an application for a DCO under the 2008 Act. This is a provision which I think will be particularly welcomed in the energy field, where currently the choice of consenting regime is actually a factor in the design of the capacity of energy projects, with many choosing to restrict to 49 megawatts so they can be brought forward under the TCPA regime. With this new power, then larger than 49 megawatt projects could still come forward under the TCPA where you can justify that. The extent to which this will be used in practice and the extent to which the TCPA system can actually cope with bigger projects, I think we'll have to wait and see. But at least there is the flexibility now to deal with that particular issue. Clauses 4, 5, and 6 make certain changes to the processes for consultation and acceptance. And of course, anybody who's applied for any promoter that's applied for a DCO yearns for acceptance. We all do. But the changes here really, I think, to some extent, tinker at the edges. The consultation report changes effectively simply require a summary of responses and changes made in a consultation report. That at least reduces the volume and the extent of those documents. But nevertheless, you still have to go through all the responses and list all the changes. So in terms of the workload, it may not make too much difference from a promoter's perspective. In terms of new duties for statutory consultees, that there are new duties imposed. They have to have regard to guidance that's going to be published in terms of their engagement on a DCO application. That's in clause 4. The government's explanation in relation to that is that it's going to seek to try and get consultees and local authorities to focus on the issues that matter. Remains to be seen whether that actually speeds the process up. In terms of the requirement to consult with those who might be entitled to make a claim for compensation during the pre-application stage, that is supposed to be removed by clause 5, although how that sits with other government guidance in relation to CPOs which encourage consultation and discussion with those who might make a claim at the earliest opportunity remains to be seen. I'm not sure that particular change makes much of a difference. The test for the acceptance stage is to be changed to a test of that the application is suitable to proceed to examination, and there are criteria published for the Secretary of State to take into account. That I think provides a certain amount of flexibility, which is lacking in the present system. Indeed, much of the DCO system since its outset in 2008 has suffered from rigidity in my view, and fails to take account of the fact that large projects are the very projects that you can't design in detail ab initio, and which do actually evolve over time, particularly during a scrutiny process such as an examination. The other change here is that the Secretary of State will be able to notify an applicant that limited changes can be made to applications at the pre-application stage, and can request additional information provided or clarifications or corrections made that would allow the application to meet the required acceptance, and a response period from the Secretary of State of 28 days is provided for. All of that seems eminently sensible to me. I think that it does make for somewhat more proportionate consultation exercises and reports to be undertaken and produced, although, as I said, whether the workload actually reduces is moot. And the ability to amend the application to gain acceptance is definitely helpful in what has been a rigid system. The real question is how much flexibility will actually be given in practice, and for that we'll have to wait and see. Moving on to clause 7, this makes a small procedural change and clarification in relation to the power of an examining authority to make costs. It imposes a new section 96A of the 2008 Act, which seeks to clarify and put beyond doubt that an examining authority can make an order for costs at any time after they've been appointed, including where an application's been withdrawn before the commencement of the statutory 6-month period for examining the application. There was some doubt as to whether costs could be awarded before the examination had before an examination had started and a DCO withdrawn. So at least we've got that clarification here, although I think it deals with the situation which shouldn't arise particularly often, if at all. Then we come to clause 8, which addresses certain issues relating to legal challenge. And in essence, what's provided for here is that a right to appeal to the Court for Appeal of Judicial Review applications challenging NPSs or DCOs that are refused permission at the oral permission hearing in the High Court and are deemed to be totally without merit. So, in other words, if you have your oral permission hearing and your ground or your claim is deemed to be totally without merit, that's it. You can't go to the Court of Appeal. It also provides for the removal of the paper permission stage in relation to these sorts of JRs. Now, will those changes actually make any difference in practice? I'm afraid I think that they're unlikely to make any material difference for the main reason that the courts rarely determine that a ground is totally without merit. In judicial reviews generally, I've dug out the statistics that are available for the last for Q3 of 2024. There were 680 applications for all judicial reviews in that quarter, and by December 24, 150 of those cases had reached the permission stage, and only 14 were found to be totally without merit. So that's all judicial reviews, including all immigration. Now, I've done in the last 2.5 years 11 DCO judicial reviews, reaching to various stages in the court hierarchy. And I can't recall a single one of the grounds in any of those judicial reviews being marked totally without merit. And that wasn't for want of asking. So I'm not convinced that particular aspect is going to make any difference. The removal of the paper applications stage, I think, is interesting, but I have concerns that then speeds up the need for a hearing in these cases, and that may lead to these sorts of cases not getting a listing in front of a judge who has particular experience of DCO cases, simply because of a lack of availability on a short timescale. There may also be issues about availability of counsel and parties having to swap counsel, notwithstanding, for example, that as a promoter, you've been working with a barrister on a major project for many years. You'll end up having to get somebody else in because they're not available on the short timescale either. So there are some concerns about that sort of process. Lastly, I was asked to look at the issues relating to transmission and community benefits set out in clause 22, which makes some changes to the Electricity Act section 38. And in essence, this comes out of the Electricity Networks Commissioner report into accelerating electricity transmission network deployment, which made recommendations with the aim to halve the total development time for transmission infrastructure. And the report specifically recommended providing community benefits to increase the perceived acceptability of new network infrastructure. And so what this clause does is to give the Secretary of State the powers to establish a scheme to apply credits to the accounts of eligible bill payers living in the properties closest to new transmission network infrastructure, with some alternative arrangements in place for an opt-in scheme where eligible persons don't have a direct relationship with a particular supplier, and so cannot receive credits in their account. So is this actually going to speed up the development time for transmission infrastructure? Well, it depends on whether getting this sort of goodie as an objector is going to make me remove my objection, and indeed whether my objection really was going to add any time to the development consent decision-making process. In my view, it's unlikely to address objections and unlikely to reduce consenting time, because I think it underestimates the public's resistance to change within their own environment. In their explanatory document, the government has explained that it's currently considering effectively paying people who live within 500 meters of the transmission infrastructure £2,500 over 10 years. In other words, your objection is worth 250 quid a year, 10 years. I'm not sure that that is going to persuade many people that is worth putting up with transmission infrastructure in their vicinity in perpetuity. In fact, I think that actually putting this forward may galvanise those who are considering objection into pursuing that objection, because these provisions will be seen as little more than a state-sponsored bribe. Indeed, the idea that one pays people a benefit which is effectively unrelated to the scheme is something that in the transport in the town country planning system has been identified as unlawful. And we can go back to the Tesco Wigley case for that. So there's an interesting change of approach compared to the TCPA system here. But as I say, I'm not convinced that this is really going to make any difference to the consenting time for the electricity transmission infrastructure. So that's where I've got to. I'm going to hand back over to Tim.
Reuben, thank you for that. I hope someone will indicate if they can't hear me. Not being unable to see me is a privilege that I think I've taken away from you all. Next up, okay. Next up is Jacqueline. And I think, again, Jacqueline is a speaker who many here will recognise, not least from her work on HS2, but she, of course, has significant experience with other infrastructure projects and with compulsory acquisition and compensation more generally under the code and other enactments providing for compensation, where statutory powers get used. She's promoted a number of transport and Works Act orders for Network Rail, including a number associated with the TransPennine route upgrade programme. She successfully obtained confirmation of the West Midlands Combined Authority, Walsall to Wolverhampton Railway Line, Willenhall and Darlaston New Stations Compulsory Purchase Order 2021. I mean, the title of these things is a clue, perhaps, to why planning and infrastructure is such a complex subject in our country. But that was the first CPO made by a mayor of a combined authority, and her infrastructure work also includes acting for the RSPB Cymru in relation to the Morley Demonstration Zone Order 2021, which is a tidal demonstration zone off the Anglesey coast. So, Jacqueline, over to you.
Thank you, Tim. As always comes at the end of the process, we get on to the compensation side of things. In a break with tradition, as in my experience is often the compensation that could take longer than the consenting process, I'm going to try and be relatively brief in terms of the overview as to the changes to compensation that was potentially coming through with the bill, and to a couple of other CPO process type changes. So the big ticket item that was headlined on our advertisement for this webinar was the changes to hope value. And just as a starting point, a reminder that we saw this first changes really come in with the 2023 Act, which inserted the new Section 14A into the Land Compensation Act 1961, setting out circumstances where prospect of planning permission could be ignored for the purpose of assessing Rule 2 compensation, and gave some mechanisms for that in the new Section 15A and the Schedule 2A to the Acquisition of Land Act 1981. And where we'd got to as at LURA 2023 was the power to include in a CPO a direction for compensation to be assessed on the basis of taking out hope value, but only in respect of enactments or schemes that were linked to housing, with affordable housing, health facilities, and then educational institutions. So there was a lot, I think, in the offing about what might we see coming through with the planning and infrastructure bill. But on my reading, or my perspective, the changes that we've seen to hope value or connected with hope value are relatively limited compared with what we got with section 190 of LURA. So in terms of the changes that have actually been proposed, really the main one in terms of extending the scope of the hope value disapplication is the insertion of one of the new enactments into the Schedule 2A. Essentially, it's the power in section 125 of the Local Government Act 1972, which is the power of compulsory acquisition of land on behalf of parish or community councils. And that's all very exciting when you read clause 91.3 until you go down to the next subparagraph 91.4, and it becomes clear that really what this is about that power being available where it's the parish council or the community council or the town council that's looking to drive forward a housing scheme with affordable housing. So it's not a broader power than that. It's really almost extending who it is who might be bringing forward a housing scheme with affordable housing to whom that sort of direction might apply. The bill also brings in some proposed amendments to the loss payments in Part 3 of the Land Compensation Act 1973. I suppose in headline terms, poor way of paraphrasing it, that they're kind of clarificatory provisions, it seems to me, making clear that when you're dealing with loss payments where you've got a 15A direction, the hope value's out for the purpose of your Rule 2 compensation, when you're assessing your loss payments, that's assessed on the same basis. I think what it does leave over, and it was quite interesting because looking at the explanatory notes to that part of the bill, it talked, or parts of the bill, it talks about occupiers and such like being the people most badly affected by upheaval caused by compulsory acquisition. The mop-up I'm still looking for is disturbance payments and how they factor in where you have a Rule 15A direction knocking out hope value. But that may be one left over for another day. But I think potentially for me, the bigger change or the biggest change that we saw with the proposals in the bill is the proposal to remove the restriction that came in with LURA 2023, that an acquiring authority can't confirm its own order if its own order includes a direction to assess compensation in accordance with section 14A LCA 1961. So that was one of the exclusions of where, no, it really has to go to the confirming authority. It can't just be confirmed by the acquiring authority, even if the other conditions will otherwise be met, no outstanding objections and such like. And that seems to me quite an interesting change or proposed change. And obviously that's part of the streamlining, the speeding up, where there's no objections, they should be able to go through quickly. But it does, to my mind, potentially raise two issues. One is this feels a little bit like it might be judge in own cause, as in it feels a little bit uncomfortable that an acquiring authority who has included a direction that means it can acquire land without paying hope value is the body who gets to ultimately decide whether to confirm that order. And that may be why there's still got to be the requirement for the confirming authority to notify the acquiring authority that they're happy for them to go ahead and do that. But secondly, it's about how the process of all of this might work. Because obviously in section 15A, we've got the process set out for when the acquiring authority submits its order to the confirming authority. You've got to have the statement of commitments. We've got the guidance as well around what the confirming authority's got to look at and be satisfied of if it's going to confirm the order with that direction in it. How does that process play out if the confirming order is going to notify the acquiring authority that they can just go ahead and confirm the order? Where does responsibility sit for carrying out that appraisal? Are we essentially going to have a situation where the confirming authority has to go through those hoops anyway in order to tell the acquiring authority that they could go ahead and confirm it. I think that's something that's going to need to see a little bit more on, to see how this in practice might work out, and check where the safeguards may still be in that process. So that comes on then to loss payments, which is, for me, the other big ticket item that we see in the bill on compensation. Two big changes, my humble opinion. One is with the changes that are proposed to Part 3 of the Land Compensation Act 1973, it does now set up this dichotomy in the legislation of different entitlements for England and Wales. Now, the explanatory notes make clear that, well, there's a power for Welsh ministers to change percentage amounts as they see fit. But it will, on the face of it, at the moment, if the bill goes through and the amendments sort of are made, there will be, at least in the first instance, a dual approach, different entitlements applying in England and Wales. And the second big change is essentially a flipping of the payments for occupiers' loss and basic loss. So as previously it was higher payments for basic loss than for occupiers' loss, it's now the other way round, or would be the other way around in England if the proposals are implemented. So the higher percentages, the higher payments will be available for occupiers' loss, and the lower levels for the basic loss. And a couple of other changes that are being made in respect of loss payments. Secondly, on the slide, there consequential amendments into each of the loss payments in Part 3 to bring in that tying up of where, if you've got your Rule 2 compensation being assessed without hope value, your loss payments are assessed on the same basis, but also a number of exclusions which apply to the basic loss or the occupier's loss payments, to do with things like whether orders or notices under the Housing Act and things like that. They've now been applied also to the home loss payments in Part 3, or would be if this goes through. So essentially bring them in line with those other payments. So on the loss payments, hopefully, I think these slides will be available afterwards. Just try to do a bit of pulling together of what the situation looks like if it all goes through as it is. Basic loss, the change will now be that in England, the payment would be whichever is lower of 2.5% of the value of the interest, the Rule 2, or £25,000. In Wales, subsection 2 would still apply, with the insertion of the words "in the case where the qualifying land is in Wales," and that's still the position whether it's the lower of 7.5% of the value of the interest or 75k. Tables get a bit more complicated when we get onto occupiers' loss agricultural land and occupiers' loss other land, 33B and 33C. I've attempted to pull them together in a tabular form to understand what the proposals would look like. So in England, for occupiers' loss agricultural land, what would be proposed would be that you get the greater of 7.5% of the value of the interest, the land amount, the buildings amount, up to a maximum of 75k. Wales, it's 2.5, land amount, building amount up to 25k, with land amount being calculated by reference to a new table, which gives values of up to, for where it's up to or at 100 hectares, £300 a hectare, greater than 100 hectares, £300 a hectare for the first 100, 150 thereafter, up to a maximum of the greater 900 cap. And in Wales, the existing provision as is would be then the lower amounts of the £100 per hectare and the £150 per hectare up to the cap of £300, and buildings amount similarly higher amounts for England and the existing, what would then become lower amounts for Wales. So those are the changes to the occupiers' loss agricultural land that are proposed in the bill, and it looks very similar for the other land, sorry, forgive me, which is in 33C. And again, I've just set them out on the slide for ease of reference to try and avoid having to jump between too many sheets of paper at any given time. In terms of CPO, other changes, just a couple to touch on. Firstly, the power for an acquiring authority to confirm a CPO with modifications. Again, this is part of the streamlining process. So before, previously, a confirming authority couldn't consent to the acquiring authority confirming an order with modifications. That was one of the carve-outs in subsection 3C. But now a confirming authority could give notice that the acquiring authority could confirm either without modification or with such modifications as may be specified by the confirming authority in the notice. So that would be a new change. Again, it's designed to pick up those situations where it's relatively minor changes and it avoids having to go through a whole confirmation separate process. If it could just be dealt with by the acquiring authority and it's otherwise unobjectionable. But it does specify, or it does provide, some limitations on what those modifications that could be included in the notice would be. Interestingly, it goes beyond the current limitations or what's set out in section 14 of the Acquisition of Land Act 1981, which just makes clear that you can include other land, but only where it's got the consent of the people affected. What's set out in clause 85 with potential changes to being proposed would be that it's slightly more nuanced. It would be you could put additional land in if it's got the consent of the landowner. You can remove an interest, and you can remove part of an interest if the interest holder consents. So again, all part of that where things are unobjectionable and the people who are affected by it are perfectly happy with it. Wouldn't not make sense to streamline this rather than having to take it off, or just maybe reach the view that maybe you could or couldn't modify it in that way and it had to go through a whole other process. Second one, changes to the GVD procedure, introduction of a new expedited procedure where you've got unoccupied land and some other conditions are met, or it also applies where you can't find the interest holder. It brings a date forward a little bit. Again, there's a whole suite of processes and strange definitions being inserted all over the place, but again, just generally part of those mechanisms that are being put in place to try and speed things up and streamline them a little bit. And also a proposal to introduce in a new section 8B of the Compulsory Purchase Vesting Declarations Act, a power to agree an earlier vesting date with individual owners. So where you've got the GVD and things being set by reference to the 3 months, what have you, this now would put on express footing the ability for the authority to agree with the owner, actually, let's vest it on X date instead. And then that has knock-on implications for things like the dates in section 7 and 8 of the Act. Although importantly, if the interest holder that you agree that with doesn't have an interest that confers with it possession of the land, that doesn't give you it doesn't give the acquiring authority, or wouldn't give the acquiring authority, the ability to go on to the land and take possession of it earlier. It only applies in respect of that interest. And just finally, one that I'm sure will be possibly most welcomed by those who are on the coalface of actually implementing CPOs when granted, electronic service provisions. So sort of bringing things in line with almost the CPR, and well, you can do service electronically if people have agreed, but also providing generally for electronic service on acquiring authorities or confirming authorities. And some amendments to the Neighbourhood Planning Act 2017, that's famous section 18, which we've all been waiting for and is still not yet in force. But essentially, it's sort of said in the explanatory notes that it sets up a dichotomy so that it'll be section 18 that applies to CPOs and to that sort of thing. But DCOs and TWAOs have their own separate regime. But it just seems to me, if nothing else, it's quite a helpful clarification that yes, actually, you can temporarily possess not only under section 2 or if there's an express act, but if you're in a TWAO or if you're in a DCO or the comparable under the Wales Infrastructure Act. So headline terms, perhaps the changes aren't quite as extensive as may have been thought might be coming forward, hoped might be coming forward, insert favoured acronym here or favoured abbreviation here, but potentially some quite useful practical changes for streamlining the CPO process. And we may just wait and see where the compensation provisions get to. On that note, I think, Tim, that brings us on to Q&A.
Jacqueline, thank you very much. And thank you to all our speakers. We do have a few minutes for some Q&A, less time than might otherwise have been the case, but I hope everyone agrees that it's been worthwhile to erode the Q&A time to have the ground covered so fully by our speakers. I think what I'm going to do is start with a question for Jenny, and then I'll most of the questions actually that we've had are really for Jenny, but I'll give her a break after question 1, and then I'll ask Neil a question, if that's okay. So I'm going to start by asking Jenny for her thoughts on this question, which has come in. How will EDPs determine or consider the amount of development which is to be mitigated? Will this be based on OAN/site allocations? If so, this could put a cap on development.
Right. Well, yeah, I mean, the EDPs are required to set a maximum amount of development that they apply to. Now, that is likely to be set by reference to what the realistic conservation measures can achieve in terms of mitigating the impact of that development. So that will be a big influence on the ambition for the EDP. Obviously, as part of that, the EDP you'd expect, although this isn't in this legislation, you would expect we'll be looking at the local plan, the emerging local plan, the OAN, and seeking to ensure that that level of development and the site allocations can be accommodated in the EDP. But there will be a constraint in terms of how much they can realistically mitigate into having regard to the funding available and the realistic levy that can be charged. And I expect there'll be some toing and froing between the setting of the EDP and the local plan process in terms of whether the local plan needs to look elsewhere if the realistic EDP can only accommodate X development in a particular area that's constrained by these, for example, nutrient neutrality. So yes, I mean, there will be a cap on development that can be dealt with by the EDP, in the sense of once that cap's reached, a developer won't be able to rely on the EDP to deal with the impact on the feature. I hope that answers it.
I hope so. Sounded like an answer to me. Next is one for Neil. We've been asked another issue on delivery is lack of expert planners, or indeed any, within LPAs. We need more trained up and incentivized not to depart to the private sector. What are your thoughts on that?
Well, I think this really goes to the fees point. If you can charge a fee which reflects the cost of processing the application, that's for a local authority, it means that you can employ more people or give the people you've got more time to consider applications. And I take a slightly different view. I think that in many local authorities, it's not a lack of expert planners or a lack of expertise. There are very many really expert people. They just don't have enough time to devote to the applications. And I think if fees were put up, more resources could be devoted, and local authority planners were given more time, their jobs would be more rewarding. They would do a better job. And I don't think they'd all just rush off to the private sector to earn higher salaries. I think there's some really good local authority planners, and this would give them the time. And as an example, I'm going to have a shout out for Ebbsfleet Development Corporation here. We have some excellent planners there, and they have the time to consider applications, which makes for better decision making and hopefully a more rewarding career for those planners. So I don't take the same view. I think with more resources could do better and would do better.
You have hope, Neil, don't you?
Neil has
I do
hope.
have hope.
What's still missing?
Let's hope that we all have hope, and I'll pass on to somebody else.
What's still missing is, show us the money. Where is all this going to be? How is it in practice? Are the numbers going to add up? But I've got to go back to Jenny, I think, with another question in relation to her topic. Can a developer pay into an EPD in advance of the plan being delivered and operational, i.e. a SANG, or does the developer have to wait?
Well, the plan itself has to set the date when it comes into force, and to be made by the Secretary of State, the Secretary of State would have to be satisfied that it can be delivered within its own period, and its maximum period for delivery is 10 years, although it can set a shorter period. But once that's in place and once it's in force, I think the intention is that the developer would not have to wait for any particular measures to be implemented for it to be able to rely on it, because the only trigger for the developer being able to rely on the carve out from the habitats regulations in relation to the specific feature is the developer's commitment to pay the restoration levy. And once they've made that commitment, they can rely on it and they don't have to go through the habitats regulations procedure. But of course, the Secretary of State and Natural England would have to be satisfied that it comes into force at the right time when the measures can be taken in a reasonable period to deal with the effects. But the answer is no, I don't think they will always have to wait for the mitigation to be effective, to have been effected before they can bring forward the development.
Well, thanks, Jenny. There's another question for you, so pause for breath. The next question is, there will be many impacts from any sizable development. How will the separate ecological features affected be identified and split out? Will it be that all development has to subscribe to all of the mitigation plans and then on top deal with ecological matters that are not covered in any of those?
Well, if a development is in a particular area covered by one of these plans, then the development in that area can choose to use that plan to deal with the particular features and the particular impacts identified in that EDP. Or if it's mandatory, we'll have to do that. But a developer outside that area clearly won't have to deal with that plan. And but the plan will not necessarily cover all impacts, because it specifically identifies the impacts it's intended to cover, and it's required to specifically identify the carve-outs it gives a pass to effectively. So it may be that there are other features on protected species or on a protected habitat that are not covered by the EDP, in which case the developer would have to deal with that separately through the habitats regulations route. So it depends really on the particular terms of the EDP is the answer.
Jenny, thank you very much. I think I must say thank you to all our speakers for this evening's presentations. For myself, I found it extremely useful. I feel much better informed to watch events as they unfold, and I hope the same is true for everyone who's been able to attend this evening. Thank you all for coming, and I hope you found this evening useful and productive. I'm now going to bring